Distinguished delegates, can you please resume your seats so we can start our plenary today? Chers collègues, chers représentants.
My dear colleagues, dear representatives, good morning. Kindly take your seats so that we may commence.
Merci.
My thanks. Judge Piotr Hofmansky, President of the International Criminal Court. Mr. Karim Khan, Prosecutor of the ICC. Mr. Registrar Peter Lewis. Excellencies, Ambassadors Louise Vassy and Momar Gueye, co-facilitators for cooperation. Excellencies, distinguished participants. I declare open the fourth plenary session of the 20th session of the Assembly of States Parties on cooperation entitled Overcoming the Challenges of Cooperation, a Common and Permanent Responsibility for the Effective Implementation of the Rome Statute. I just wanted to remind you that this meeting has been called in conformity with the decision taken by the Assembly at its 11th session, in which the Assembly noted with satisfaction the need to include cooperation as a standing item on our future sessions of the Assembly's agenda. Last year, that was not possible because of the COVID-19 pandemic, but I'm delighted that this year, despite the ongoing difficulties of the pandemic, the Assembly has been able to do this in plenary and on an annual basis, underscore the importance of cooperation, heightened cooperation with the court as part of its mandate. I wish you all fruitful discussions. I'm delighted to take part in the first segment of today's plenary with my distinguished colleagues of the course. And now I should like to hand this part of the plenary into the able hands of the co-facilitators on cooperation, Ambassador Vassy and Ambassador Gueye, who have some introductory remarks for this plenary session, which is so vital for the court's work. But before handing over to our co-facilitators and getting into the first, to the main item of this morning, I just wanted to go back briefly to 6A on the item of, as an item of our agenda, which is the appointment of the Credentials Committee. Now, as you'll remember, we already have 8 out of the 9 members of the Credentials Committee members. Upon recommendation of the Bureau, I would like to suggest that South Africa be designated to occupy that remaining 9th seat. May I take it that the Assembly agrees with this proposal? It is so decided. And now I should like to hand over to the co-facilitators. Ambassador, you have the floor. Thank you very much, Madam President. Mr. President, Mr. Prosecutor, Madam President of the Assembly, Excellencies and Ambassadors, ladies and gentlemen. Allow me, first of all, since I'm going to be moderating the first segment, and also on behalf of my esteemed colleague, Ambassador from Senegal, Momar Gueye, let us offer you a warm welcome to this plenary session on the cooperation here at the 20th session of the Assembly of States Parties to the Statute of Rome. I should like to thank our President, Fernandez de Gomendi, for having opened the session. Ladies and gentlemen, Facilitation on cooperation, as you know, is something that Senegal and France have had the honor of undertaking for the last 5 years, and it has just one goal, and that is to assist with the implementation of the commitments that we all took when we ratified the Rome Statute in terms of cooperation with the court. This is a key pillar of the Rome Statute system, and without which the court wouldn't be able to discharge its mandate. And that's why last year, at the height of the pandemic, we undertook the commitment to moderate during the assembly sessions a plenary session thereafter, so as to maintain and strengthen the mobilization among states and all other stakeholders in terms of cooperation. And this year, the Ambassador of Senegal and myself, despite the pandemic, have been able to ensure that this could be done thanks to the trust placed in us by the ASP and the Bureau. So we've continued to work on, along with different organs of the court, to explore different ways of strengthening cooperation through pragmatic and operational perspectives, and in particular with a focus on the 66 recommendations on cooperation adopted in 2007 by this Assembly, which still guides us today. We were also called upon, like all facilitators, to take part in the assessment and follow-up exercise on the IER recommendations, particularly those concerning cooperation, the court's cooperation with regional international organizations, and the practical modalities for legal assistance between the OTP and states parties. And the results of this you'll be able to see in our report at the Bureau. So this is a long-term undertaking, and next year we'll be able to look at different issues, nonetheless very important ones. We thought it was important to remind everyone here at this plenary session of some of the issues specific to cooperation that weren't actually able to be discussed during the review process this year, and yet which are still vital for our work to continue. Remember that we're talking about voluntary cooperation, cooperation with in terms of financial investigation and identifying and freezing assets. So we hope that we'll have active and interesting exchanges with you today. And now I'd like to hand over to Momad Gueye, who's going to get into more detail about the structure of our plenary meeting this morning. Thank you, my dear friend. Good morning to one and all, friends and colleagues. Thank you for those preliminary remarks, which I do think cover what we are going to be doing today, and I think which give you a good introduction to the issues at hand. Madam President, Mr. President of the Court, Prosecutor, High Representatives of the Court, and President of the Assembly, ambassadors, ladies and gentlemen. Before getting into an introduction to our program today, I just wanted to thank all of the representatives of the organs of the Statute of Rome, which have enabled this plenary session to go ahead. I also wanted to express my thanks to the states parties and observer representatives, as well as those representatives of civil society organizations. Now, we have given this session the title, Meeting the Challenges of Cooperation, a Common and Permanent Responsibility for the Effective Implementation of the Rome Statute. So through that wording, what we really wanted to highlight was the fact that the success of implementing the Rome Statute really does depend, to a large extent, on the level and the quality of cooperation that the ICC can count on vis-à-vis all different kinds of stakeholders, including states and international organizations. And that's why we focused on the collective aspect of this responsibility, as well as the fact that it really is an ongoing commitment, a long-term commitment. So this morning's plenary is going to be broken up into two parts. The first segment is the high-level segment looking at the voluntary cooperation aspects, which is very important. So after the opening statements that we'll hear by Madam Silvia Fernandez de Gurmendi, we will have the opportunity to hear from a series of speakers, Firstly, Piotr Hovmansky, President of the Court, Mr. Karim Khan, the ICC prosecutor, and Mr. Peter Lewis, the Court Registrar. After that, we will be handing the floor over to two states parties who have signed the voluntary agreements, France and North Macedonia, who will be able to share with us their reflections and respective experiences in this matter. And then we'll be hearing from other states parties and interested participants, and we'll be able to have their reactions. And then the second segment is another very important aspect on cooperation in the field of financial investigations, identification and freezing of assets, towards the establishment of a network of operational focal points. And there again, we'll be able to hear from Amady Ba, who's the head of the section of international cooperation at the OTP, Madame Anne-Aurore Bertrand, who's in charge of external relations and cooperations within the registry. But also we'll be able to hear from Madame Alejandra Vicente, who's the legal director of Redress NGO, which has been working on some of the issues concerning the financial investigation and their impact, and on international cooperation in financial investigations, identifying and freezing assets. After we've heard from all of those states, parties and other participants, again, we'll be able to ask any questions if they so desire. So up to there, I'll hand back over to my colleague Luis, who's going to moderate the first panel. Thank you very, very much for that, Mama. So the first segment, as we said, was about voluntary cooperation. And for this first segment, then, what we wanted was for the high representatives of the court to underscore some of the key challenges regarding cooperation that they are having to face. And so then they'll have a chance to look at the different issues surrounding voluntary cooperation, and in particular cooperation agreements, but also obviously any other issues that they might feel relevant. This segment is also going to be a chance for states parties to share their experience, as we said before. And obviously, I'm delighted to have with us them here with us. So I would suggest then that we get started with you, Madam President of the ASP, so that you can share with us throughout your long experience some of your experience over this. Thank you. Thank you very much. First of all, I just wanted to thank the co-facilitators yet again, Ambassador Ngeye and Assi, for having given us a chance to discuss this together, and on how to bolster cooperation with the ICC. I just wanted to underscore three key aspects for the ASP this morning. Firstly, I wanted to remind everyone that cooperation is crucial for the court's operations, and that member states, states parties, do have an obligation to support the judicial functions and investigations of the ICC by via concrete operation in all different stages and activities of the court, as provided for by the Rome Statute. I also wanted to underscore how important it is to ratify the agreement on the ICC's privileges and immunities, which protects the integrity of the judicial process and guarantees the inviolability of staff and assets and communications of the court. In 2007, the Assembly adopted a founding document containing a thorough list of 66 recommendations on this very issue, cooperation. And these recommendations identified the priority areas and key challenges in terms of cooperation. They provided not only a snapshot and a direction to be followed, but they also suggest different practical solutions that may assist with overcoming challenges. Measures for follow-up were also taken, for example, by distributing among state parties different flyers describing the different ways of implementing the recommendations, and a questionnaire in 2016 concerning implementation. Ever since the adoption of that in 2007, the recommendations of the ASP on cooperation have proved very useful as an orientation and a guide, and with ongoing relevance for states parties and the ICC. And I'm convinced that by further bolstering cooperation of states or with the court, we'll be able to guarantee greater efficacy, credibility, and independence. Secondly, I just wanted to reiterate the vital importance of ensuring that states do have rules and procedures that are clear in nature so as to be able to provide or ensure these different forms of cooperation with the court as their obligations dictate. Over and above their specific cooperation obligations under the Rome Statute and the Agreement on Privileges and Immunities, there are also other forms of voluntary cooperation that are very, very important to ensure that the court and its work remain efficacious and that trials are swift and fair. So I would encourage all states to sign those framework agreements on voluntary cooperation so as to facilitate this vital cooperation, which means that investigations and trials can go ahead smoothly. The presentations that we'll be hearing today concerning the experience of 2 states that recently signed these kinds of agreements with the court are very important, and their expertise is going to be most useful for this assembly, and it will give us a clearer idea of what can be done at the national level. And finally, a third and final question that I think is just as important is to understand how to establish a coordination mechanism between the national authorities on the one hand, dealing with issues of cooperation with the ICC. And in this context, the second segment, which is more technical in nature, is going to be an excellent forum for a constructive dialogue among all states parties on how to intensify their efforts to establish a network of national focal points in charge of coordinating effective responses to requests for cooperation by the court when it comes to financial investigation, identifying and freezing assets. It's also important to underscore in this regard the signature, or the adoption rather, in 2017 at the 6th session of the ASP, the Declaration of Paris on financial investigations and assets, which did so much to boost heightened cooperation in this regard. So, Excellencies, distinguished participants, I just, by way of conclusion, wanted to thank you again for having given me the chance to take the floor here in this forum, and I'm happy to take any questions you may have. Thank you.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Now I should like to hand over to the President of the Court, who honors us with his presence. Mr. Hofmanski, you have the floor.
Excellencies, distinguished delegates, ladies and gentlemen, it's indeed a great pleasure to address this plenary meeting on cooperation. This is a crucial topic. Without cooperation, the court would not be able to perform its mandate. Full cooperation with the ICC's investigations and the prosecutions is arguably the most important obligation that states assume when becoming parties to the Rome Statute. The various forms of this obligation are detailed mainly in Part 9 of the statute. At the same time, there are also several key areas in which we need states to come forward with voluntary assistance. One of these is enforcement of sentences. The court does not have a prison of its own, and the sentences it pronounces cannot be enforced without the cooperation of state willing to receive the convicted person. Yet, this is not a strict obligation of any single state party. Rather, it is a shared responsibility. This is why we need as many states as possible to join the list of state parties willing to accept convicted persons. This is done by negotiating and concluding a framework agreement with the ICC presidency, which consolidates in one document all the legal provisions governing the enforcement of sentences. I would like to stress that the conclusion of this agreement does not yet bind the state party to accept any sentenced person. This is because designating the state of enforcement operates of the principle of double consent, means states must first declare willingness to accept prisoners in general by concluding a framework agreement, and then again in a specific case. When a sentence pronounced by the ICC becomes final, the ICC presidency selects the state of enforcement from the list of states which have indicated their general willingness. In doing so, the presidency considers many relevant factors, including the principles of equitable distribution, the views and nationality of the convicted person, and international treaty standards governing the treatment of prisoners. And as I indicated, we must also obtain in advance the agreement of the state to receive the specific prisoner in question. To date, 13 state parties have signed framework agreements with the court on the enforcement of sentences. The latest of one being France 2 months ago, for which we are very grateful. But additional agreements are needed to share the responsibility and to ensure sufficient flexibility. This is particularly important as more and more ICC proceedings reach the enforcement phase. Excellencies, ladies and gentlemen, before I finish, I would like to echo 2 important points made by the President of the Assembly. These are the ratification of the Agreement on Privileges and Immunities and the national implementation of the Rome Statute to provide national procedures for cooperation. These crucial steps should be taken by all state parties to the Rome Statutes. However, almost half of them are yet to do one on the other or both. Accordingly, I urge renewed attention of these important issues. Implementing the cooperation obligations in national law is crucial for the sake of ensuring smooth and efficient cooperation with the court on concrete requests and to avoid any situation in which a lack of adequate provisions in national law would hinder a state from carrying out its obligations. The APIC is an essential complement to the Rome Statute as it defines in greater detail the necessary privileges and immunities of the court and its personnel. Classic examples include the protection of the court's property from search and seizure and the inviolability of the court's documents and communications. These are not matters of convenience, rather they are essential guarantees for the court's independence and the integrity of its investigations and proceedings. As such, the APIC has a real impact on operational efficiency. When the courts need to conduct a mission to a state that has not ratified APIC, precious time must be used to seek advance guarantees of the necessary privileges and immunities by other means. Excellencies, ladies and gentlemen, I would like to finish my remarks with an expression of gratitude to France and Senegal for all their efforts as co-focal points on cooperation. I also reiterate the Court's gratitude to all states and organizations that extend their cooperation as well as crucial political support to the International Criminal Court. Thank you. Thank you for your attention.
Merci infiniment,
Thank you very much, Mr. President. I would now suggest that we now hear from Mr. Karim Khan, the prosecutor of the court, share his viewpoint with us from the OTP's angle.
Madam President, Silvia Fernandez de Gamende, Mr. President Hofmansky, Mr. Registrar Peter Lewis, dear Ambassadors Louis Vassy and Momar Gueye, it's really a great pleasure to say a few words about cooperation. I also have to acknowledge the very great amount of work that you both have done as co-facilitators in previous years, but also during the strictures of COVID-19. I think there's a great deal that to be proud of in the work that's been done, and I think everybody owes you and colleagues that have worked to support you a debt of gratitude. For my part, if complementarity is seen as the foundation of the Rome Statute system, cooperation must be seen as the edifice that surrounds the house that was built at Rome. Nothing, absolutely zero, can be done without cooperation. We cannot set foot in a territory without cooperation from a state party. We work based upon the principle of legality, complying with visa requirements in a way that is necessary in an international organization and a judicial institution that respects the rule of law. Cooperation also is dynamic. And I know the next session that has been intimated is dealing with financial crime, but I think we go back to the Paris Declaration of 2017, and it shows that talk can lead to action. A framework can be put forward acknowledging that in this very advanced world that we live in, where there are interlacing elements of criminality, we need to accelerate our efforts to use modern technology. Otherwise, we're going to keep playing on a losing wicket. We're going to keep playing catch-up, and we're not going to make meaningful inroads in the quest of accountability. This has to be brought forward from simply financial investigations to every other area of endeavor. All of us now armed with a phone can see fake news, can see hate speech, can see so much based on social media, and of course there's the dark web. We need to be equipped to confront, to investigate, to analyze, to preserve, and then to produce relevant evidence to judges in due course that may be relevant to the facts that are an issue. Social media is a particularly important one where greater cooperation and assistance is needed. National legislation, I know, is a hot topic in certain capitals, in certain countries, regarding regulation. But when we have an international criminal court such as this, where there's cooperation and an acknowledgement, including by the Council in certain cases, that crimes that also cause threats to international peace and security are being committed, we may need to look at more innovative ways in which cooperation from social media companies can be compelled or should be much more easy to be provided to the office of the prosecutor. We are, of course, not engaged in political activities. We're not engaged in peripheral political prosecutions. We're dealing with crimes of genocide, crimes against humanity, and war crimes in particular. So this is an area I think we need further work on. In addition to that, of course, telecommunications. We see cell site data is increasingly important. It's been used in some cases before the court, but it's now part of the basic toolkit of any domestic investigator. We need to find, as an office, more partners, more cooperation, so that rich data sets that are available in the handsets that people carry about them and the devices that people use in terms of cell site evidence and harvesting that data and scrubbing it can be obtained. The other aspect of cooperation, of course, is it's not only binary. It's not only between the state parties or non-state parties and the court. It must be both ways. And as I mentioned on the opening plenary, I referred to Libya and the joint investigative teams with the Europol, with Italy, with the United Kingdom, and with the Kingdom of the Netherlands. We need to do much more of this. And this afternoon, I know President Silvia de Gamendi, myself and others, there's also a side event on mutual legal assistance. This is a wonderful example of cooperation in which states, between themselves, are looking at creating linking more synapses together so that the brain of the international community can have more information to make inroads on crime. I think this is a very important aspect. I certainly hope, and I don't want to bring budget discussions in there, but I really hope, and I have a vision for the office in which we have a world-class e-discovery system that will allow us to harness, collect, and analyze multiple data sets from investigations we're looking at, where very often we see common actors that are working across territorial jurisdictions. This will not only help our investigations in the office, but would be a wonderful repository for us to be a hub, also helping domestic authorities, national authorities or regional authorities. Genocide Network, of course, is already there, but there's many more that we need to work towards if we're really going to stop chasing our tails and making really impactful, squeezing those, reducing the space of those that are committing these awful violations against our brothers and sisters and the children of the world as we sit here. So we need to have this sense of urgency. We need to take these ideas from the paper of diplomacy or legalese into concrete action, because if we do that, we can then combine with domestic law enforcement, domestic evidence gathering, and have ever greater accountability. So there's much more that can be said, but I don't want to be called to order for speaking too long. But I just really think this can be a joint victory for all of us if we have ever more cooperation. And I think it is not beyond our wit to seize the moment and look at that. And that will require partnerships also with, whether it's NATO, whether it's the Organization of Islamic Conference. I don't see why we can't have privileges and immunities. Seek them, even with non-state parties. Try to do that more widely so that even if a country doesn't sign up to Rome, the principles of Rome, we can still operate for various other investigations or witness interviews or other types of activities in their territory in an agreed and transparent way. So if we think in a new way, I think we'll get better results. Thank you so much.
Merci beaucoup.
Thank you very much, Mr. Prosecutor, for having shared with us your outlook. And I would now like to turn to the Registrar, Mr. Peter Lewis.
Thank you very much, Madam President, Mr. Prosecutor, Excellencies, ladies and gentlemen. First of all, can I express my deep thanks to Ambassador Geyer and Ambassador Vassi for their continuing commitment to ensure the issue of cooperation remains on everyone's agenda. Those who have worked with you, like myself, over the last 3 years, realize just how much effort has been required any progress we managed to make, and all of us in the court are very grateful to you. I also want to express my thanks to all the states who cooperate and help us every day. We have an enormous amount of requests for cooperation, and I'm delighted to report we have a very strong commitment from you. But particularly, I want to thank those states who have signed voluntary cooperation agreements with us, including, of course, recently France and North Macedonia. Each one of these agreements is a precious gift to the court. However, the simple issue is we do not have enough of these agreements, and in some areas of the world, and in respect of some cooperation, some sorts of cooperation, I'm afraid we have little or no agreements in place. I want to use the example of witness protection to illustrate both some of the success and the cooperation we've already secured, but also the challenges ahead. If you follow the live streaming of our cases, it will be obvious to you that we rely on witness testimony. Behind each of the witnesses you see when you tune into the court's channel, there is a support program for that witness, and usually for their families too. That support program is to ensure they're safe where they are, they're protected if necessary, and we're able to get them from where they are to a place where they can give evidence. Now, in most cases, that support can be given in the country in which the person operates, where they live. We do not wish to move people away from their families and communities unless it's absolutely essential. And the witnesses we're dealing with don't want to leave their homes either. But in a small but crucial number of cases, about 20 to 30 cases a year, we have to relocate individuals. Now, when we need to relocate them, we rely on the network of states who have signed voluntary cooperation agreements with us. And with North Macedonia, we now have 23 such states. But as I've mentioned, we haven't got enough. And I want to give you the example to illustrate the problem. In this year that's just gone by, 2021, we have only been able to place 5 witnesses and their families in protection. For the remaining 16 witnesses and their families, we have had to resort to short-term ad hoc measures to find safe refuges for them while we try and secure a place for them to be relocated. Now, on a very simple, practical term, that is a very, very expensive exercise for the court. To find, at short notice, places that will be able to keep our witnesses safe for a short period of time needs an enormous amount of time and effort, and of course we have to move them discreetly too. But more importantly, the people we are moving are usually traumatized people. And if they're not, they've just gone through a life-changing experience when they realized they had to be relocated. And I do mean a life-changing experience for them and their families. What they need is to find a secure place to re-establish a life as soon as they can. And we can't do that because we simply haven't got enough agreements in place to make this a smooth process. Now, Most of these witnesses can be adequately protected by simply moving them away from the place they're in danger. Most of the people we need to relocate do not have special needs. They just have the same needs that we all have as individuals. A place to live, a place for our children to go to school, some access to medical facilities, and some modest financial support while they find jobs and establish a new life. So, in many cases, that's all we need is for you to be able to receive these people into your refugee program. Now, there are some cases where the people do have special needs. They're very vulnerable. They may have been insider witnesses. They may be traumatized by what they've done as well as what they've experienced. And we are lucky, very fortunate in this court, that we have a number of relocation agreements with states who are experts in this field and are willing to help us with these difficult cases. But we need more of you. Now, I just want to emphasize some points about these agreements. And this is in respect of witness protection. The first is, these agreements are flexible. We don't expect every state to be able to offer all the forms of protection that we might conceivably need. The ability to give somebody a home and nothing more is something that is very precious to us. Secondly, and as the President of the Court has mentioned, this too is a double consent arrangement. The state always retains the decision-making power to accept or reject a specific individual. And as I know, looking around this room, there are many of the states who want to personally assess the witnesses and victims concerned to ensure that they can manage the risks and look after them properly. It is also an entirely discreet process. We will not tell anyone that we have asked a state who signed an agreement that we've asked you to take a particular witness. We will certainly never tell anyone what your decision is, and we will never reveal that a witness is on your territory. And I know for political reasons, discretion is important as well as operational reasons. Indeed, we will not publicize that you have such an agreement with us unless you want to. And some states do not want to, and we understand that. And finally, a fund is available to pay for the costs of relocation of witnesses. And due to your generosity, that fund is full at the moment. We have no problems in finding the money for you. Now, I've used the example of witness protection to illustrate the problems, but we also need cooperation agreements on the issue of final release, where we only have one agreement at the moment, and interim release, where we only have two agreements. We're enormously grateful to the states who have signed those agreements, but frankly, we need more of them. And I finally want to add and just emphasize the point that the prosecutor has made. We all aspire for this court to be a universal institution, but we will only have such an institution if we have universal cooperation to match the membership of the Rome Statute system. Thank you very much, ambassadors.
Merci beaucoup.
Thank you very much. I thank all of the panelists for their very pointed comments with a lot of concrete observations that demonstrate that while the court was established by states, and as such lives on that very basis to facilitate its work. If states, as our minister recalled in his opening address at the beginning of this session, to guarantee its judicial independence, well, we're actually in a rather special situation where the action of the court requires action on the part of states. And the examples that have been mentioned actually give us reassurance. States cannot be kept out of the system. Rather, they have to fully engage in cooperation so that the court that they themselves have established can discharge its duties to the fullest. Today, we've heard mention made of agreements for the enforcement of sentences, relocations, etc. There are issues of mutual legal assistance, sharing of evidence, etc. So the entire judicial life of the court and beyond the judicial life, everything hinges on cooperation. That is one of the very bedrocks of the agreement that we've signed, alongside complementarity. And I'm very pleased to hear that the people who are in charge of working on complementarity will make it possible for us to work more closely together. Now we have some statements from people in the field, and I was a rather random choice, but we're going to start with the French delegation, who I now recognize. Good morning, everyone. France has provided support to the ICC from the very beginning, especially when it comes to the field of cooperation. The signing of a framework agreement would be an extension of France's cooperation with the ICC that's already been established here in The Hague, as stated by the chair of the working group on cooperation, with a view to fostering all forms of cooperation with the court and especially facilitating the fulfillment of its mandate. In 2012, the court proposed with France the negotiation of a framework agreement for all sentences handed down. The agreement was signed between the president of the court and the Minister of Justice in October 2021. And what it does is establishes a framework for accommodating people sentenced by France. The court can also turn to France to be a place of the enforcement of sentences in order to make it possible for the court's warrants to be rapidly executed. That's the advantage of a framework agreement. It makes it quite clear upstream what different operational and legal criteria will be attendant with this. Starting in November 2020, we signed a Memory of Understanding signed by the Minister of Justice of France, and this is how we had online meetings negotiating with the legal team of the President's cabinet and coordinated by France by the Legal Affairs Department of the French Foreign Ministry and of European Affairs. So now we have to engage in consultations in order to focus on things such as the articulation between domestic legislation and international standards, and more importantly, the applicable law to the convicted, including changes in sentencing, reduction, lightening of sentences, etc. Then we have issues related with the conditions of detention, and this would be under the aegis of the ICRC's committee on that. France would be following and forwarding any observations about this. And thirdly, the complexity of actually monitoring the status of the convicted in France. Now, despite the pandemic, we managed to have a successful round of negotiations after 9 months of online consultations. This negotiation was fast-tracked and made it possible for us to come up with a framework agreement that is satisfactory to both sides when it comes to the law that would be applicable to this. So now we're just awaiting the final stages of approval in France. The agreements on the enforcement of sentences are essential. The number of the courts, people in detention and being sentenced by the courts could rise significantly. There's been an additional agreement for the enforcement of sentences with 13 other countries. France would be eager for us to have a broad-based negotiation in order to make sure that we have a framework agreement of cooperation with the court, without which the court cannot do its job. Thank you.
Merci beaucoup. Et sans plus...
Thank you very much. And without further ado, I shall now give the floor to the delegation of North Macedonia.
Thank you very much. Madam President, Excellencies, distinguished delegates, ladies and gentlemen. Since I'm taking the floor for the first time at this ASP, first I would like to congratulate you, Madam President of the Assembly, on your election, but also to express my congratulations to the new President of the Court, the new prosecutor, as well as the judges elected during the last session of the Assembly. On behalf of North Macedonia, we wish them every success and assure them of our support. I would like to also welcome this plenary debate on the most important issue of cooperation as one of the key topics of ASP agenda. In this regard, I wish to express my gratitude to the ambassadors of France and Senegal for their continued efforts as co-facilitators on cooperation. My country has always been a strong supporter of the ICC and is firmly committed to the independence, integrity, and efficient functioning of the court since its creation. We believe that the establishment of this institution with a jurisdiction over the most serious crimes is one of the biggest achievements in the development of international law and the protection of human rights. But it is also one of the main pillars in the fight against impunity. Therefore, we as state parties must invest continuously in its success, which depends heavily on cooperation with states and international organizations, as it was accented in these debates already. This is why my country has recently engaged in negotiations with the ICC and signed a voluntary cooperation agreement. I would like to convey the appreciation for the smooth cooperation with the Office of the Registrar during the negotiations and signature of the agreement. The exchanges went smoothly and in spirit of mutual confidence and understanding. The agreement establishes a framework for cooperation between our competent institutions and the court and introduces clear procedures for concluding operational agreement for each individual case for which the competent authority has given its previous agreement. We entered these negotiations following our conviction in the following: that the court needs our full support to execute its mandate, that we have a responsibility to help in protecting the most vulnerable as a value of the democratic world, and that we can jointly enhance the capacities in the fight against the most serious crimes of international concern. Furthermore, I'm convinced that the ICC will find a credible and serious partner in the competent institutions of North Macedonia, which in turn will be able to further develop their capacities while cooperating with the ICC. I would like to use this occasion to also welcome the recent signing of an agreement on the execution of sentences between France and ICC. In this regard, I'm sure that our two countries would like to make a joint call once again to all other state parties to conclude voluntary agreements with the court in all priority areas identified so far, including the execution of arrest warrants, voluntary cooperation, cooperation in financial investigations, and freezing of assets. In conclusion, let me reiterate the readiness of the Republic of North Macedonia to continue to provide political support, cooperate, and actively participate in the activities of the International Criminal Court. Thank you very much.
Merci beaucoup, Madame l'ambassadrice.
Thank you very much, Madam Ambassador. Now, I see that we are running slightly behind schedule, and so without any further ado, I should like to hand over to any states parties who would wish to take the floor, and there were some who were already registered before we concluded. I see Mexico has requested the floor. Mexico is here with us.
México.
Mexico, please. Thank you. Thank you, Mr. Co-Facilitator. Thank you. Thank you very much. Madam President, distinguished delegates, judges and officials of the ICC, representatives of civil society. As is the case in any international system, cooperation among states and between states and the international mechanisms is vital if you're going to get positive outcomes. The international system of criminal justice is no exception. In conformity with Article 86 of the Rome Statute, cooperation in terms of financial investigations and the tracing and freezing of assets, implementing arrest warrants and orders for surrender, and all other kinds of cooperation are absolutely vital if the court is to appropriately discharge its mandate and end impunity with those who have committed the gravest of crimes against humanity. We must never forget that cooperation is also absolutely vital if we're going to provide reparations to victims and affected communities. Madam President, Mexico welcomes the surrender of Mr. Mohamed Said Abdelkhani to the ICC by the CAR authorities, which was on the 24th of January of this year, and calls on all member states to continue in their assessment, in their assistance when it comes to fulfilling the 12 outstanding arrest warrants and requests for surrender. States parties need to do their utmost to enable the court to fulfill its mandate, particularly when it comes to promoting and modifying national legislation so as to enable this cooperation, as well as enhancing internal domestic procedures so that these warrants and requests of the ICC can be implemented in a timely manner. By way of conclusion, I don't want to let this opportunity slip by just to remind everyone that the system designed by the Rome Statute as a complementary body so as to support the efforts of those member states who wish to strengthen their national capacities for judging the crimes foreseen in the Rome Statute. And that is why the ASP enables us these kinds of fora, and so that we can discuss opportunities for cooperation and enhance our cooperation with the UN and civil society organizations, leaving the court to get on with its judicial work. I want to thank all of you for the opportunity to deliver this statement on behalf of Mexico. Thank you. Thank you very much, Ambassador. Now, I was wondering if the other speakers who had registered on our list would like to take the floor. I had, as a second speaker, the United Kingdom. Do they wish to take the floor?
Vous avez la parole.
The floor is yours.
Thank you, Ambassador, for giving me the floor. The Court relies on the cooperation of its states parties to carry out its mandate in full. As a strong supporter of the Court, the UK has been pleased to assist. This has included practical support to the Office of the Prosecutor in relation to a number of investigations and preliminary examinations. As states parties, we must also take our share of responsibility for protecting witnesses and enforcing sentences. The UK entered into a voluntary cooperation agreement with the Court on the protection of witnesses in 2004. Since then, we have implemented a multi-agency approach to ensure that requests are dealt with promptly, including by designating a central point of contact for receiving and dealing with requests for assistance. We have regular scheduled meetings with the ICC on cooperation issues. The UK also entered into a sentence enforcement agreement with the Court in 2007. The UK currently serves as the enforcement state in relation to a custodial sentence imposed by the court. We remain ready to share our experiences with other states who are considering entering into a voluntary agreement with the ICC. Thank you.
Merci beaucoup.
Thank you very much. I suggest we move on then to the Netherlands delegation.
Vous avez la parole.
The floor is yours.
Chair. The Netherlands would like to thank the co-facilitators for their efforts on this important issue. As the host state, the subject of cooperation with the court is very dear to our heart. After all, the court relies on our cooperation in many areas, ranging from the security and protection of the court's premises, officials, witnesses and suspects, to the transportation of defendants. For the relocation of witnesses, the release of persons, and the enforcement of sentences, the court relies on voluntary cooperation with states parties. This form of cooperation is of crucial importance to the effective functioning of the court. Voluntary cooperation agreements provide a general framework that allow considerable flexibility to a state party to grant or refuse cooperation in a specific case. One would hope that this combination of importance for the court and flexibility for the state party would lead to the conclusion of many such agreements. Unfortunately, until now, far too few agreements have been concluded. These past few days, however, many speakers have underlined the importance of voluntary cooperation, so we are hopeful that the number of concluded agreements will continue to increase. The lack of voluntary cooperation has a strong negative impact on the effectiveness of the court. In addition to all the time, efforts, and resources the court has to put towards resolving issues that arise due to the lack of cooperation, it also compels the court to rely more heavily on those states that have concluded such agreements. The Netherlands commends France and North Macedonia for signing of cooperation agreements and calls on other states parties to follow in those footsteps. Let us live up to the principles enshrined in the Rome Statute and share the responsibility of voluntary cooperation amongst all states parties. Thank you very much.
Merci beaucoup.
Thank you very much for your statement. And now I should like to hand over to Belgium.
Merci, messieurs.
Thank you very much to our co-facilitators. First of all, I wanted to thank the senior officials of the court for their most enriching presentations. And I just wanted to say, remember that cooperation is a shared obligation of all member states if the court is to achieve its goals as assigned to it by the Rome Statute, and in particular, particularly as concerns the OTP, nothing would be achievable without such cooperation. Now, Belgium just wanted to issue a few remarks concerning how it has undertaken reshuffling internally in order to enhance cooperation with the court. Firstly, we have a central authority on cooperation with the court, and this means that we can better deal with any requests for cooperation from the court. Secondly, in 2004, we adopted specific national regulation concerning requests for cooperation stemming from the court. These means that this is legislation covering the different fields under which obligatory cooperation might come about. For example, be it air transport of detainees, protection of witnesses and victims, tracking and seizing assets, etc. And thirdly, we have cooperation agreements with the court, with the presidency, the prosecutor, and the registry, and such accords, such agreements are part of what we call the obligatory cooperation. But also, we have the issue of voluntary cooperation. And Belgium has concluded such agreements, for example, with the provisional release, resettling of protected witnesses, or air transport. And signing such agreements meant that we needed close dialogue, and this was only possible thanks to the excellent outreach of the Court. It's important to remember that such agreements cannot enforce any additional obligatory cooperation. The requests for cooperation are part of a framework of voluntary cooperation, and these are examined on a case-by-case basis in Belgium. The framework set up in Belgium through the designation of that central authority and now the adoption of the internal domestic regulations concerning cooperation agreements and the signing of cooperation agreements means that the central authority in Belgium is able to deal with a growing number of requests for cooperation from the court. I've got Mr. Bastien Renard here with me today, and remember that you're also free to contact him if you have any further requests for voluntary cooperation. Now, I just wanted, by way of conclusion, to mention that that it's not only cooperation with the court, it's also cooperation between states that is of vital importance if we're to enable the court to discharge its mandate. And there's an important side event today, presided by our president this afternoon. And our prosecutor will be there as a speaker at that side event. We welcome you all there. Thank you. Thank you very much to the Belgian delegation. And the final speaker on my list for this first panel is Sweden.
Qui doit demander la parole?
Who needs to request the floor so that I can hand them the floor?
Madam President, distinguished members of the court, excellencies, ladies and gentlemen. First of all, thank you, excellencies, colleagues from France and Senegal for organizing this important plenary. We join in recognizing that in the course of investigating, trying cases and executing judgments, the ICC has to rely on the cooperation of states in areas such as assistance in investigation and evidence gathering, making arrests, transferring the accused and executing judgments and acquittals. The witnesses and their families must be protected and many times relocated. Sweden has entered into 2 voluntary agreements, one concluded in 2007 on relocation to Sweden of witnesses, and another one on the enforcement of sentences in 2017. Our experience of cooperation with the court on these agreements is very positive, and we are committed to continuing cooperation and lend our support to the court, and we are happy to exchange best practices with other states. Based on this experience, Sweden is also happy to encourage others to enter into voluntary agreements with the court. Thank you.
Merci.
Thank you very much. I have no further requests from the floor from the states, which means that I'm wondering if we should move over to the civil society statements. With my colleague, we were very privileged to have 2 coordination meetings with civil society organizations concerning the co-facilitation on cooperation, and these were very, very enriching. So with civil society, I only have one request, which is Amnesty International. I'm happy to hand you the floor.
Sure, Mr. Chairman. On behalf of Amnesty International, thank you very much for the opportunity to address this Assembly session on the issue of cooperation with the ICC. Amnesty International believes that the Assembly's annual standalone session on cooperation provides an excellent opportunity to discuss practical solutions to the cooperation challenges the court is facing. This year, discussions on the seizing and freezing of assets provide an excellent opportunity to discuss how assets of convicted persons can be used for the benefit of victims through reparations awards. In a similar manner, it is important to recognise that the term voluntary cooperation is perhaps an unfortunate misnomer in its implication that such cooperation is not essential to the proper functioning of the court. In fact, the court can only function if states parties are willing to enter into voluntary agreements with the court, and we continue to urge states parties to do so. One area of significant concern surrounds the lack of willingness of states parties to enter into voluntary agreements with the court in relation to defence matters, or to matters related to accused and acquitted persons. In our ASP20 statement entitled "States Must Consider the Impact of Their Current Decisions on the Future of the ICC," Amnesty International raises the concerning situation of Mr. Charles Blégaudet, who is unable to leave the Netherlands, indeed The Hague, after his acquittal. We urge states to urgently consider the issue of acquittal relocation agreements, and we call on the Netherlands to consider its obligations, which it may necessarily incur as the host state of the ICC, as it relates to cooperation and acquitted persons. We note that in the final report of the independent expert review, the experts highlighted the negative impacts of a lack of states parties' cooperation on the court's operations. Unfortunately, and in keeping with the experts' seeming unwillingness to critique states parties, the experts did not provide substantive recommendations to the Assembly on how cooperation could be improved. However, it is worth recalling the experts' findings within the report, and in particular critical findings in relation to cooperation in the context of preliminary examinations, the tracking and arrest of court fugitives, ICC investigations, and defence-related matters. Amnesty International urges the Assembly to pay close attention to the experts' report and to consider its own performance shortcomings in oversight and governance, and the impact that these have had on the court's performance and the fulfilment of its mandate. Cooperation and complementarity must go hand in hand. We call on the Assembly of States Parties to pursue how the Office of the Prosecutor can share, with its states parties, information or evidence it has preserved of crimes under international law in the Afghanistan situation, including crimes committed by the ANSF, the CIA, and US military. Indeed, states parties must cooperate with the court and assess how their national authorities can operationalise any information or evidence gathered by the OTP in the Afghanistan situation. States parties have the obligation and capacity to ensure investigations into the heinous crimes committed in Afghanistan and are yet to do so. We note, for example, that the Office of the Prosecutor had specifically examined CIA black sites in states parties Lithuania, Poland, and Romania. Ultimately, if the ICC is to be seen as part of a broader Rome Statute or international justice system, states parties must cooperate with the court and step up to ensure investigations of all parties and all persons suspected of committing crimes under international law, including those traditionally seen as allies. Thank you.
Je vous remercie beaucoup.
Thank you very, very much for your statement, and this, I think, does demonstrate how very much interest there is here, is that we've run over time. So I just wanted to wrap up by thanking the high-ranking panelists, as well as the member states and representatives of civil society who took part in this discussion. So I suggest that we change now the seating arrangements up here on the podium and get ready for our second segment. Thank you very much.